Um, just by way of introduction, the tribunal is composed of Mr. Akshay and I'm Purvi. Would the teams please introduce themselves and just give the time split before we get into the arguments?
Definitely. Good afternoon. My name is Ayushi Singhal. And my colleague, Ms. Akshay Jose. Each of us will speak for 14 minutes, reserving 1 minute each for rebuttal. We are going as respondents.
And Kaylee Smith, representing the claimant on merits. My colleague Brian Famler, representing claimant on procedure. We will each speak for 14 minutes and 1 minute for rebuttal.
Thank you, teams. Have the teams agreed on the procedure and the order in which they want to go?
Excuse me, if you could clarify the order of speaking once more. We'd be still going arbitration first and then moving to merits, right?
Yes.
Yeah.
The parties have agreed for respondent to commence on both procedure and merits, followed by claimant.
And the rebuttals will follow the procedural arguments and then subsequently the merits argument, or do you want to do them together at the end?
Rebuttals will follow the arguments they relate to. Thank you.
Members of the tribunal, if I may. Members of the tribunal, counsel for the claimant, good afternoon. My name is Ayushi Singhal, and together with my colleague, Mr. Akshay Jose, I represent the respondent, Mediterranean Mining. This dispute revolves around the validity of the Colton purchase contract by our client. Before this dispute is finally settled, I shall make two jurisdictional submissions before this tribunal. First, concerning the joinder of Global Minerals to the present dispute, and second, related to the validity of the emergency arbitrator's order. The final issue on merits will be addressed by my co-counsel, Mr. Jose. Moving on to the first issue, we submit that Global Minerals should be joined under Article 7 of the ICC rules to the present dispute. This we submit because of two reasons. First, that Global explicitly consented to the arbitration agreement by virtue of its signature and endorsement in the contract. And second, and in the alternative, that the group of companies doctrine should be used to join Global to the present proceedings. Moving on to my first submission in this regard, we believe that although Global was not explicitly named as a party in Article 1 to the contract, it did sign the contract with the knowledge of the arbitration agreement in the contract. Initially, when the contract was being signed, our client, Mediterranean, was skeptical of the financial capabilities of Vulcan Colton, which was the reason why we always wanted some form of involvement from Global in the present contract. Subsequently, Global asked for a 0.5% reduction in the price for the Colton, and it was in return of this accession of their request that we believed that Global will then always stand by the contract. In a similar case of Stellar Shipping Company versus Hudson, the English courts have ruled that when a parent company endorses the contract, it becomes a party to the contract by virtue of two reasons. First, that endorsement is a personal obligation, and arbitration is a personal obligation, and endorsing such a personal obligation can only mean its acceptance. And second, that endorsing all the clauses in a contract without any reservation to the arbitration agreement only amounts to the acceptance of the arbitration agreement also.
Counsel, in this case, had they not said that the only obligations that they're undertaking are payment obligations and not any other obligations? Wouldn't that also include the obligation to arbitrate?
Mr. Arbitrator, in this regard, I have two submissions to make. First, that the facts of the present case are silent as to whether they explicitly took only the payment obligation upon themselves. And second, even if they only took the payment obligation in the contract, it needs to be noticed that in a normal commercial contract, each and every dispute arising out of each and every provision of the contract has to be arbitrated. It is not that a certain clause in the contract is excluded from the arbitration.
Is that true, counsel? Are you aware of the entire contract on the record? And is it not possible theoretically to say that certain kinds of disputes will not be arbitrated and will be settled by way of litigation, and only certain kinds of disputes will be referred to arbitration?
Definitely, Madam Arbitrator. As an answer to that question, if I may draw your attention to page 7 of the record, which is the contract in the present case, Article 20 of the present contract clearly says, if I may quote,
Counsel, these are excerpts from the contract. You don't know if there's any other provision in the contract that may say except for, provide an exception for Article 20.
Madam Arbitrator, while I may agree that that might just be a circumstance in the present case, in the present contract, Article 20 describes the provision for arbitration. It is logical for the parties to include all the provisions related to arbitration in a particular article only. And therefore, we believe that since in the present excerpt, Article 20 is the only contract dealing with arbitration, in case the parties would have wanted to provide such a reservation, they would have done so in the present contract, Article 20 only.
Counsel, what is the impact of the doctrine of separability to this analysis that you've just done?
Madam Arbitrator, while we agree that arbitration agreement is a clause separate from the major contract, however, we do not require another signature on the arbitration clause in the particular contract. A signature to the whole of the contract suffices even when the separability
Let's pause
principle...
a little bit there. Is there a difference between a signature and an endorsement?
Yes, Madam Arbitrator.
Counsel, what is that difference?
Mr. Arbitrator, presently there is no case law or commentary in the jurisdictions involved in the present dispute which could describe the meaning of the term endorsement. Therefore, we have to look at the intention of the parties to ascribe the meaning to this term.
What was the intention of the parties, counsel?
Madam Arbitrator, the parties intended that Global Minerals should be involved in the present case.
And how is that discernible? Would you have any facts to back up that claim?
Yes, Madam Arbitrator. To answer that question, if I may move on to the group of companies doctrine argument which I'll be submitting.
But
Counsel?
isn't that a different argument?
Yes.
Madam Arbitrator, to answer that question at hand only, if I may draw your attention to page 16 of the record. Paragraph 3 of the said page clearly shows the intention on behalf of Global Minerals to enforce their rights in the arbitration of the arbitration agreement. If I may quote, it says, Theostorm writes in this present letter, we are determined to enforce our rights in arbitration and ask you to give us an assurance that you refrain in the meantime from any actions. This is an explicit recognition on part of Global Minerals that they wanted to be a party to the arbitration agreement.
Okay, counsel, see Exhibit C7.
Yes, Madam Arbitrator.
Dear Mr. Summer, we hereby formally avoid the contract. Just because the term we is used, that's just to indicate that the person who's writing the letter is actually representing the company. which is a reference restricted to the claimant and not to Global Minerals.
Madam Arbitrator, in the present case, Theo Storm, the COO of Global Minerals, had no authority to act for Vulcan Colton, as is evident from page 63, paragraph 7 of the record. In such a circumstance, when Global Minerals acts for Vulcan Colton, the only conclusion which our client Mediterranean Mining can draw is that Global Minerals is in fact wanting to participate in the contract and is a major party in the contract.
Counsel, shouldn't you have raised some objection as to why Mr. Theo Storm was communicating with you, particularly because he was not a party, he did not have authority on behalf of the claimant, and because Global Minerals had explicitly rejected the proposal that it be added as the additional buyer?
Madam Arbitrator, our client did not feel any need to clarify this because of Global Minerals' conduct in the present contract, which was so explicit and concluding towards its being a party to the contract, that our client felt no need to clarify the same on behalf of Global Minerals.
Counsel, can you go to paragraph 7 of page 63?
Yes,
On the fourth line, it says, at Global Minerals, Mr. Storm was responsible for Vulcan.
Yes, Mr.
Then
Arbitrator.
towards the end, it says that it was agreed that Mr. Storm would contact Mr. Winter, given that they knew each other much better. There is no representation of Global Minerals anywhere. If you look at all the emails he sent, he signed off as Storm and not COO. The designation is always important to determine on what grounds are you actually representing a company.
Mr. Arbitrator, to answer your question, I have 2 points to make. First, that even though it is evident from the record that Global Minerals had a responsibility for Vulcan Colton, Theo Storm had a responsibility for Vulcan Colton back at Global Minerals, this was never made clear to our client Mediterranean Mining. And since that was the situation here, we in good faith always believed that Global Minerals was a party to the contract. In answer to the second question, it was always that Global Minerals was sending the letters also on behalf, that Mr. Storm was sending the letters also on behalf of Global Minerals. By way of example, if I may draw your attention to Exhibit C6 of the record.
Which page comes in?
Yes, Mr. Arbitrator. I apologize. Exhibit C10 of the record, which can be found at page 16. In the beginning of the said letter, it explicitly says that it was sent on behalf of Global Minerals. This is a clear indication of the fact that it never believed that it was acting solely on behalf of Vulcan Colton or in its personal capacity. Therefore, it is clear indication of the fact that Global Minerals wanted to be a party to the contract. I shall...
Just 1 second.
Yes, Madam.
Just to take you back a little bit, before this you said at some point of time that we need to evaluate the conduct of the parties.
Yes, Madam.
What is the legal basis for evaluating the conduct of the parties different from the express terms of the contract? When the contract does not list Global Minerals as an additional party or as a party, how can we look legally to extraneous circumstances of conduct?
Madam Arbitrator, in this regard, initially when the negotiations were taking place, we do believe that Global Minerals rejected being named as a party to the contract. However, Article 4.3 of the UNITHROA principles explicitly says that subsequent conduct of a party is an important determinant of proving the intention of the parties.
You're missing the question. The question is that if explicitly the contract says something, what is the legal basis for reading another interpretation or something outside of the contract into the same relationship that is governed and crystallized in the written form in the contract?
Madam Arbitrator, the threshold for doing the same is when the conduct of a party goes against what is expressly written in the contract. This has also been held in the 2003 case by Federal Supreme Court of Switzerland, wherein the Supreme Court lays down that when the conduct of a party goes against the explicit terms of the contract, that conduct has to be taken into consideration for proving the actual intention of the parties. If I may move on to my next submission. In the course of this argument, I'll be substantiating the three core elements of the group of companies doctrine, which are the common intention of the parties to buy in global minerals, the substantial involvement of global minerals in the present contract.
Counsel, seeing as you have less than 2 minutes left, perhaps do you want to summarize this argument and move on, address us on the emergency arbitrator?
Definitely, members of the tribunal. I have already substantiated the substantial involvement of global minerals and the common intention of global minerals being a party to the contract. Therefore, I need to substantiate Vulcan Colton and global minerals forming one single economic reality. If I may draw your attention to page 64 of the record, paragraph 9, it clearly shows that Vulcan Colton had a mere asset value of 20,000 US dollars. Further, paragraph 7 found on page 63 clearly shows that Vulcan Colton was only approving the emails sent by Global Minerals and the major control on those emails was of Global Minerals. This shows that Global had functional and financial control of Vulcan Colton and therefore they indeed were a single economic reality. Having substantiated that the group of companies...
You have half a minute left of your time. Do you perhaps want to summarize and move on to the emergency arbitrator arguments?
Yes, Madam Arbitrator. In the course, there are two conjunctive requirements for this tribunal to invalidate the group of the emergency arbitrator's order. One, the jurisdiction of the emergency arbitrator, and two, the prerequisites, the substantive prerequisites of the emergency arbitrator's order should have been met. Proving either of these conjunctive requirements should be sufficient for this tribunal to invalidate the order, and therefore I shall be substantiating that the emergency arbitrator did not have the jurisdiction to grant the order. If I may draw the attention of this tribunal to page 7 of the record, Article 21.
Counsel, you have exactly 1 minute to summarize your argument.
Yeah, you've taken up all your time, Counsel.
I apologize for this, members of the tribunal.
1 minute to summarize your argument.
Article 21 of the contract gives the exclusive jurisdiction to grant provisional measures only to the national courts of the respondent. Further, the use of the term shall in Article 21 also is an indicative of the fact that this recourse to national courts was mandatory and not permissive. Further, the background of the facts in which this article was included in the present contract is a conclusion to the fact that the parties wanted to avoid any controversy as to which fora would have jurisdiction to grant the order. Since in the present case, by the interpretation which claimants seek to give, there can always arise a confusion as to whether the emergency arbitrator or the national courts have jurisdiction.
Counsel, please conclude.
In conclusion, I submit that this tribunal should hold that Global Minerals is indeed a proper party to the contract and should be joined to the present proceedings. And second, that the emergency arbitrator's order should be invalidated. Thank you.
Thank you.
Counsel, you can proceed.
Thank you, Mr. Arbitrator. Sorry, Mr. Arbitrator, I'm getting some feedback when I speak. May I request for the microphone to be muted at your end?
Sure.
Thank you. Members of the tribunal, by way of reintroduction, my name is Brian Famler on behalf of claimants. I'd like to begin my submission by respectfully requesting for this tribunal to please disregard respondent's submission on the basis that it is unfounded. The real reason we are here today is because respondent is attempting to avoid its contractual obligations. Now, the reason why they're using this strategy, or opposing counsel is using this strategy, is because it has no legal basis to its views. In light of this, and on behalf of both claimant and Global Minerals, we submit two procedural requests for this tribunal. Our first request is for this tribunal to allow the current arbitration to proceed, but without the need to join Global to the current arbitration. Our second request is for this tribunal to maintain the interim orders issued by the emergency arbitrator on the basis that it had the jurisdiction to do so. With regards to the first argument which opposing counsel has raised, and if I may, I'd like to add that I will address the arguments raised by opposing counsel in the same order, that is the issue of consent, followed by a group of companies doctrine. With regards to consent, opposing counsel has used Stellar and Shipping as a way to provide a meaning for endorse and attempted to link the term endorse to mean consent. What claimant would like to submit is that this tribunal should look to the current facts of this case and the current facts of this current arbitration to find the true meaning of the term endorse. Now, claimant concedes that the meaning is not very clear, and there's a very good reason for this, and that's during the negotiation between claimant and respondent, neither party had actually defined or made clear what this term endorse means. What is clear though, yes, Madam Arbitrator.
Counsel, who proposed the term endorse during the contract negotiations? And once you've answered that, please direct me as to why we should not apply the rule of contra preferentum and interpret it against you.
Thank you, Madam Chairman. With regards to your first question, it was actually proposed, the term endorse was proposed by Global Minerals. And in this case, this tribunal should not be applying the rule of contra preferentum because the arbitration clause, which is Article 20 of the contract, which you'll find on page 7, is not in itself ambiguous. What is in dispute in the current case is whether Global has provided consent to be joined of this arbitration, and that cannot be found within the text. Thank you for the question, and that actually supports my next line of argument in that because it was Global that suggested that... yes, Ms. Howard.
The contract as it's signed says it's endorsed for Global Minerals. It's been introduced by one of the parties. Although it's not in the text of the article, there is an ambiguity that has been caused because it's been inserted here. So, principles of contractual interpretation are being applied to the term endorsed. So since there is an ambiguity, why would contra preferentum not be applied here, although it's not in the text? We don't understand whether or not it's in the text of Article 20 is relevant here.
Thank you, Mr. Arbitrator. In this case, like opposing counsel has submitted, we would need to look at the conduct of Global Minerals to find the true meaning then of the term endorse. Now, at all times, Global has made it very clear that claimant would be the only party to the contract. In fact, opposing counsel has conceded that Global actually explicitly rejected respondent's attempt to join Global as a party under Article 1 of the contract. Now, the purpose of creating a subsidiary in this particular case was to keep all, all business separate between claimant and Global Minerals. So these actions collectively, which is in fact supported by respondent with Mr. William Winter, he actually states that the exact legal status of Global Minerals is of little concern, and that's because the contract has been provided a guarantee through the letter of credit. And so I fear in this case, opposing counsel and also respondent has mistakenly tried to connect endorse with consent.
Counsel, two questions. One, what exactly was Mr. Theo Storm's role in this contract, and who is he representing? Because he has no authority to act on behalf of the claimant. So who is Mr. Theo Storm representing? And two, under Article 4 of the contract, the obligation was upon the buyer to issue the letter of credit. So why was the letter of credit issued by Global Minerals?
Thank you, Madam Arbitrator. With regards to your first question, the role of Theo Storm in this case, that was simply to relay the information that claimant had towards respondent, and that's purely because they have a history and it's a much smoother channel for lines of communication to happen between claimant and respondent. Now, I will note at this point that opposing counsel turned the tribunal to page 16 of the record, and I will read, "We are determined to enforce our rights in arbitration." In this particular case, Global Minerals has always acted with the approval and always with discussion from claimant. So by Theo Storm actually sending this communication to respondent, it was merely relaying the information on behalf of claimant to the respondent. Madam Arbitrator, also in ICC case 4504, where a third party communicates to one of the parties, that conduct itself is not sufficient to bind that third party to the arbitration, because there is lacking any form of consent. And as I mentioned, Global at no point has provided any form of consent. With regards to your second question, you noted that it was the buyer to issue that line of credit. Then why did Global Minerals provide that line of credit? Well, the commercial reality in this particular case is that claimant is a very new company, and a subsidiary does not create itself. A subsidiary will need to be created by someone or something. In this case, it was created by Global Minerals. Now, just because a subsidiary is created doesn't mean it can then operate by itself. It needs an injection of funds. And so by Global Minerals providing funds to claimant, it was merely in progress of creating such a subsidiary. In fact, if we were to accept opposing counsel's... Yes, Madam Arbitrator.
What is the most important obligation on the buyer in a sales contract?
In this case, it would be full payment.
Who undertook that obligation?
Article 4 of the contract actually shows who is responsible for that payment, and that is the buyer, in this case, claimant.
So for the purposes of Article 4, when Article 4 says that the buyer shall establish the letter of credit, you disregard that and you say that Global Minerals is going to establish the letter of credit. But for the second part of Article 4, which says payment is to be done by the buyer, you can't interpret the same word differently for the purposes of the same clause, counsel. And if there is
If I caused any form of confusion, Madam Arbitrator, with Article 4, it was always the buyer that undertook any payment obligations under the contract. Now, I believe what you are getting at is that if Global Minerals then provided some form of guarantee, does that mean that Global has undertaken the obligations of the buyer? In this case, no, it hasn't. What it has is provided a guarantee separately to claimant. So claimant still has the obligations to provide payment, in this case for the 30 tons of coltan, and looking at it from that, Global Minerals does not have a particular role, which I believe will answer the second part of your question as to why Global Minerals was involved in any form of line of credit or the issuing of the letter of credit. Madam Arbitrator, I'm very conscious of my time. If I may, I'd like to proceed to address the group of companies doctrine raised by opposing counsel.
Please proceed.
Thank you. Madam Arbitrator, opposing counsel has suggested that we can skip certain parts of the elements that form the group of companies doctrine because Global has already participated in the contract negotiations, performance and or termination, and that it expressly provided consent. We submit that, and we have already submitted that it has not provided consent, as endorsed in this particular case, has not amounted to consent. Any involvement with that Global has had was only to introduce claimant to respondent, and that is just a business reality because it is a smoother channel for claimant to have with respondent because of the history that Global has with respondent, which again is independent of its dealings with claimant and respondent. Though when those two parties have communicated, it is completely independent of any involvement of Global. Because any involvement with Global merely amounts to linking, if you will, claimant to respondent, and no consent has been provided, this tribunal should disregard the group of companies doctrine. Madam Arbitrator, unless there are further questions, if I may, I'd like to address the jurisdiction of this tribunal with regards to the interim orders issued by the emergency arbitrator.
Go ahead, Counsel.
Thank you. Thank you, Mr. Arbitrator. Article 29 of the ICC rules, in conjunction with Appendix 5 of the ICC rules, explain very clearly the procedures for requesting interim measures. Now, these measures operate on what's called as an opt-out basis. That is, they will operate automatically with regards to a dispute arising out of an arbitration agreement concluded after the 1st of January 2012, which is what we have here. The only time that these emergency arbitration provisions do not apply is when the parties have expressly opted out or they have chosen to replace with another pre-arbitral procedure that grants similar measures. Now, I note that opposing counsel has not raised under 29.6c. What opposing counsel has done is that 29.6b, which is expressly opted out, that they have chosen to expressly opt out of the arbitration provisions, and that's why it does not apply. However, Appendix 5 actually makes this quite clear for the benefit of the tribunal, in that in order to expressly opt out, the words must state within the arbitration agreement that the emergency arbitrator provisions shall not apply. One merely has to examine the contract, and in this case, the arbitration article, to demonstrate that they have not expressly opted out. Yes, Madam Arbitrator.
Counsel, are you making a reference to the model clauses?
That is correct, Madam Arbitrator, I am.
Counsel, are model clauses mandatory in nature?
In this case, no, they're not mandatory in nature, and you can, or a business or contracting parties can choose to use a different wording, if you will, to the same effect. But 29.6b, and according to Appendix 5 of the ICC, Appendix 5 of the ICC rules, specifies that in order to opt out under Article 29, you must expressly state that you do not wish for the emergency arbitrator provisions to apply. Thank you for your question, Mr. Arbitrator. Thank you. I'm very aware of my time, and if I may, I'd like to take 30 seconds to conclude my submission.
Counsel, could you just point us once the particular provision in Appendix 5 that you're referring to?
Thank you. Madam Arbitrator, it's actually on page, where is it? I apologize, Madam Arbitrator. If I may, in the course of the proceeding, I will find that and provide that to this tribunal.
Counsel, there was a 2013 case decided by the ICC which had a clause which said the exclusive jurisdiction to grant interim measures would lie with courts. Now, in that case, the ICC tribunal held that this amounted to an express exclusion and opt-out of the emergency arbitrator clause. How would you address that case, Counsel? Because the ICC itself has interpreted it in that manner.
Well, in this particular case, the parties have not expressly opted out. And as I mentioned, you can only, those arbitrator provisions, Mr. Arbitrator, can only be removed with reference to 29.6b or 29.6c. And we submit that in this particular case, it has not been satisfied.
Counsel, could you conclude your arguments, please, since your time is now run out?
Thank you very much, Mr. Arbitrator. I would like to simply conclude by submitting that this arbitration proceeding can go ahead. And in fact, the contract between claimant and respondent can go ahead. There is no need for respondent to try to attempt to join global to this arbitration, and the measures should be maintained so that in the event that this tribunal were to grant an award in favour of claimant, that respondent would be able to fulfil that award. Thank you very much.